Gentlemen and ladies and gents, welcome to another edition of the EON channel production. We got some information that we wanted to share with you all. We're going to make this video really quick. Not going to keep it long, not going to keep you long. We had to point out certain things that some of you were unaware of. So the first thing we're going to do is talk about dispute resolutions. UNCTRAL recognized arbitration. That means everyone who is a part of the United Nations, all of the nations, all of the 180 blah 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 nations who are part of the United Nations must have an arbitration clause, must recognize the right of the people in the country, the companies in the country, to have arbitration, especially dealing with commercial transactions. Okay? See? Oh, by the way, let me make sure you understand where this is coming from. United States Department of State. So these are the rules, but there are more rules than these rules that you need to be aware of. What do you mean? Well, pay attention to this right here. This right here is an individual's report on arbitration. And look, this article is from Dispute Resolution Journal. Okay, but notice this, the Revised Uniform Arbitration Act 15 years later. After the, pay attention, 2000, year 2000 is when they came up with the Revised Uniform Arbitration Act, the UAA revised, RUAA. What's the UAA? If they had to revise it, what was the original? Well, the original was called the UAA. What is the name stand for, son? Uniform Arbitration Act. Dang it, that's why it's called the Revised Uniform Arbitration Act. What's wrong with you? All right, ladies and gentlemen, Dispute Resolution Journal goes ahead and highlights to you all, and all you got to do is download it. It gave you the title. So all you got to do is download it, and you can find out about how they originally came up with the Uniform Arbitration Act 8 years after they came up with the FAA. FAA was, oh, I said 8 years, and it was correct because they came up with the FAA, Federal Arbitration Act, in 1947. 1947. So with 1947 to 1955, that's 8 years. Why did they come up with the Uniform Arbitration Act? Because the Uniform Arbitration Act refers to the United States of America. And they couldn't call it the UFAA, UFA, because whoo, doggy, so many people would have played around with that phrase, that acronym. So many acronyms. Look, there's a new acronym. It's called the Uniform Arbitration Act, promulgated by the National Committee or Conference Committee, blah, 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 on so-called uniform social laws. That's not what the S stands for. Statutory laws. Pay attention. We're going to go to what that stupid committee is so that you guys can understand that this committee is not elected by any official. Okay? This committee, the National Conference of Commissioners on Uniform State Laws, are not elected officials. It's a private corporation, and they create those so-called regulations and laws. They're called administrative regulations, administrative laws. They are permitted to do this under the Administrative Procedures Act. All you got to do is go read, people. That's what allows them to create these laws. And then Congress will enact certain provisions of laws that are put together by them. Okay? But because they give public notice, like the uniform, what is it? The uniform, dang it, I can't think of the name of it. It's where you get your mortgage, Satisfaction of Mortgage Act, the Uniform Satisfaction of Mortgage Act. This is the same committee that created that junk. Or the Uniform Commercial Code, same committee. Okay, what gives them the right to do that, ladies and gentlemen? The so-called ABA. ABA? Well, no, it's called the Administrative Procedures Act, not the Administrative Procedures Act. So the APA, Administrative Procedures Act, Title V of the U.S. Code. Okay? So there you go. Ladies and gentlemen, let's deal with this former Judge Meyerson. I don't know Meyerson. I know that he's Arizona Court of Appeals and General Counsel for Arizona State University, is a mediator and arbitrator in Phoenix, Arizona. He is an adjudicated professor at the Sandra O'Connor College Law Library at Arizona State University, where he teaches courses on arbitration and mediation. He is a past chair of the American Bar Association section of dispute resolution and State Bar of Arizona section of alternative dispute resolution. He is a member of the board of directors of the American Arbitration Association. Ladies and gentlemen, let me make sure you understand. All of these are private positions. Every single position they listed here, including this one, is a private position. So he leaves being a judge and he becomes an arbitrator. If you all thought that you needed some special skills to be an arbitrator, just because he was a judge does not make him an arbitrator. Just because he was a member of some college and some mediation and a part of the American Bar Association or the American Bar Association's American Arbitration Association. Yes, the American Bar Association created the American Arbitration Association. So that wasn't a far leap for him. Okay, all arbitration associations are private associations. You will learn more about that when you read over the EEON'S trial, Arbitration Association rules. Okay, however, some people think they can just go out there and just start an arbitration association. I don't know where they're getting that information from. I don't know who's publishing that information, but they need to stop. Because you can create your own arbitration association. Here's the unique thing you have to do. You have to follow the rules, people. There are some general rules that are already in place. Some people already have an idea of what those rules are. But guess what? Guess what? You want us to guess? Not really. I want you to just take a look here, and I just want you to go to arbitration rules. And then EEON'S trial arbitration rules as revised 2010. Just click on it, people. It'll take you there. Okay? And then all you got to do is review the information. Make sure that your organization complies and falls in line with that. I am, for the most part, speaking to the Yusufs and the Jonas, because I think once people understand this process as an alternative means to the court, then they'll get it. Now, there is something I have to show you guys. I want to show you, so give me a second, okay? But I have to pause you for a second, so you guys don't have to excuse me. Gotta find my mouse. Ladies and gentlemen, I want to admit I've never heard this song before by Diana Ross. It's called Blame It on the Sun. I know of Stevie Wonder's version of the song, but I never heard of Diana Ross. What you're looking here is this is the Washington State Court of Appeals. What they have done is they decided to dismiss a case that was put before it. I'm going to give a brief explanation of this case. We filed the case. We filed, basically this company filed a claim against this young lady, and this was a debt collection case, so we filed a counterclaim. And in our counterclaim, we raised certain points. Well, guess what? That company defaulted. They never responded to our counterclaim. They were in default. They lost. They never showed up to a single hearing. They lost. So we demanded the court grant our claim. Since there were no challenges to our claim, the court dismissed both cases without reason or cause. Never gave a reason for the dismissal of our case, so we did an appeal. The appeals court came up with all kinds of excuses. The other party never responded to the appeals court. So the appeals court ordered them to respond or said they will hold them in default. But when it was time to hold them in default, they dismissed the appeal. Ladies and gentlemen, you cannot win with the courts. Sorry, because they are not fair. It is not equal access. No matter how much evidence you have against the other party, they will not let you win, especially if you're doing videos and publishing your wins on computer and the internet. This is to certify that the Court of Appeals for the State of Washington Division 2 considered and granted the motion to dismiss the appeal. Who gave a motion to dismiss? The clerk of the court. On October 8th. Accordingly, this cause is mandated to the Superior Court from which the appeal was taken for further proceedings according to the determination of that court. Okay? So guess what, ladies and gentlemen? I want you to pay attention. The clerk of the court did this, not the actual court. That's one. This is from the Ninth Circuit Court of Appeals. A review of the record reflects that this appeal may be frivolous. Why? Because we did a habeas corpus. Because we're saying the right to property and taking the property of the all caps name, which is the defendant, we're doing a release the body. The court may dismiss the case at any time if the court determines the case is frivolous. I want you to pay attention. So they want us to file a motion dismissing the appeal, why the appeal should not be dismissed. Okay? Now, guess who put in the motion for dismissing of the appeal? If the appellant does not move to dismiss this appeal, the court may dismiss the appeal as frivolous without further notice. Any determination of whether the appeal is frivolous will be based on the opening brief received September 18, 2018. So they received the opening brief. But guess what? The appellant's statements, if any, in response to this order. The briefing schedule for this appeal remains stayed. Now, why are they staying this appeal? Because, pay attention, the clerk of the court, they didn't like the fact that we sent them the contract. That's right, they got a copy of the contract. They won't be able to dismiss the appeal. Do you know why they won't be able to dismiss the appeal? Because we put them in contract. Ignorant mother. So I will take care of them in due time. But this is my showing you that we could not have come up with a better avenue than going straight to arbitration because of the ignorance. Now I gotta let you go, guys, because I got a lot of paperwork to do, and it is a lot of work. So have a good day, have a good life. Just wanted to bring you up to speed on arbitration being international and that the courts are not a viable means, an adequate means of remedy. Let me show that to you before we go. Okay, let's see if I can get to that section. You know, I wish it wasn't like this. Challenge, disclosures by and challenge of arbitrators, replacement of an arbitrator, repetition of hearing, repetition of hearings in the event of blah, blah, blah. There's a statement made in the... No, hold on. I got a better way of showing it to you. Sorry about that. Let's go to the top. The courts have said that arbitration is an alternative remedy for going to court because it's expedient and it costs less and it's less of a burden on the court. Sorry, I can't find that because this is the document for SAA. So I can't find that right now. I wish I could. I wish I had planned on showing that to you. But again, that's the reason for it. Okay? The courts are not an adequate means of redress because they're administrative as well. You have no, in the United States, you have no access to justice. Hey, wait a minute. The Dow Jones, wait, now I gotta show y'all this. I just got this little flash from ABC, DOWJON. Uh-oh, it wants me to do the whole thing. LIVE. Let's see what's going on with the Dow, y'all. Cause look at that, 653 points. Man, somebody told y'all the beginning of this year, 2019 was not gonna be good. Now remember, I want you guys to understand, they were at 26,000 points. Okay, and in the month of November, they were at 25,700. Okay, you see, this thing is saying 22,000. That was this morning. That's where they are now. So let's do 6 months. Let's let you guys see where the Dow has been in whoa, look at that. They were right here, December 3rd. They were at 25,800. Okay, 25,800. They have lost almost 6,000 points, ladies and gentlemen. Almost 6,000 points since December 3rd. They definitely lost 5,000, but they're on the verge of losing 6,000 points in pay attention, in 1 month. Ladies and gentlemen, the stock market, every 1,000 points is $1 trillion. The stock market doesn't operate that way. Okay? It doesn't lose those type of points in a month. But notice the swing. Up, up, up and away. 25,800. And then here we are right here. How much? 26,191. That's November 8th. Like I told you, they were at 26,000 November. Now they're at 21,000. Almost, pay attention, almost 6,000 points. Another 1,000 points and it will be 6,000, but it is exactly 5,100 points in less than a month. 20 days. Okay, do you understand? That's 20 days. Now you got to take away the 6 days within the 20 days that no trading is being done. So that gives us 14 days worth of trading, and it's lost 5,000 plus points. That's why they can say it's the worst year for the stock market and blah, 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 blah. But they were doing so good over here when they hit 26,000, a new record high. Not anymore, because we're all the way down here. Okay? So that's just to let you guys know. All right, gotta go. Said we're gonna keep this short, and we haven't kept this short. Gotta go.